Again, members, let's not get confused about what's happening here. The major policy change for water quality, for injection wells, for sewage, for toxic chemicals. The amendments are to Chapter 26 and 27 of the Water Code and 361 of the Health and Safety Code. Also impacts the Clean Air Act, and it says that the community now has to hire the experts, hire the lawyers, undertake the modeling, undertake significant expense if they don't want one of these permits in your backyard or in their backyard, okay? In my view, it should be the applicant, the people that are coming to the community and requesting the application that should make that case, but not the burden of proof in SOA hearings. In contested cases should not be shifted to the community, to those who are affected persons, as it says under the law.
Mr. Speaker,
Under Section 5, Spot 115 of the Water Code.
I'd like to ask the gentleman a couple of questions.
Mr. Anchia, do you yield?
I yield.
Let me try to put this. I'm a country lawyer, suburban lawyer. I understand what burden of proof is and so forth. But for the members of this body, for them to understand, and I know you're being technical about all the various things, this really does boil down about 40 years worth of change in the burden of how they process this. And does this not mean that if you make an application now, all you can do, you can apply with anything, and the entire burden of proof, the idea that it's unsafe, is on somebody wanting to contest it versus someone making an application and saying, we believe it is safe, and being able to prove that up. Is that correct?
And of course.
Wait a minute, is that correct?
Yes, it is correct.
Okay,
once you get to a contested case, it is correct.
Right, in a contested case. And at the end of the day, it affects every member in this body and their constituents and everybody who may have concerns that the person making the application doesn't really have to prove it's safe. It's up to you to prove it's unsafe.
At the SOA hearing, that would be absolutely correct.
Is that what the amendment
That's
did?
what's going
and
on.
So you are trying.
Just to be clear.
And so just so the body knows, you are trying to undo Mr. Chisholm's amendment, and I'm sure it's brought with all the due respect and in good faith about what he thinks is necessary to do in this process. But it affects every member that when your constituents call you and say, what can we do about it? It's not that the party has to prove it's safe and say, we made this application, it's contested, we have some burden of proof here. It is the idea that we have shifted that burden to your constituents and to other groups to come in and prove that somehow it is unsafe. Is that right?
That's right. In the Texas Administrative Codes currently, in Section 30 TAC 80, Spot 17 Sub A,
you know what?
So TCEQ, I'm just telling you where the site is. The TCEQ has made, through their rules, a judgment that the burden of proof is on the applicant, on the movant. Okay? This changes that TCEQ rule. And last I checked, the TCEQ has not been an enemy of industry. I mean, I think they're very fair with industry. So I don't believe that this would create an undue burden on behalf of industry. I think it creates an undue burden for the people who are contesting these cases.
Let me tell you something. I don't think that some of the members here, and I know I don't have a sterling record on environmental issues like you do, Mr. Anchia, but at the end of the day, this is a pretty darn big change. Is it not?
It's a big change, Bert.
And quite frankly, when you're shifting the burden of proof like this, members need to know whether they're for it or against it, what exactly they're doing when they get contacted by their constituents.
I agree with you, and frankly, I think this merits a little bit more discussion than putting a bill on a sunset bill.